The Whistleblower Protection Act, what companies really need to implement. That's what this video is about. Reports of legal violations are to be handled securely and confidentially. But what is truly necessary and what isn't? What might be good to implement? Opinions often differ on this topic. The purpose of the whistleblowing directive, or what the legislator intended to achieve with it, is on the one hand the protection of whistleblowers, the early detection of misconduct in general, and of course the promotion of open communication and a culture of openness. The law is therefore not an end in itself, but rather an instrument for preventing damage within the company. But who does this law actually apply to? In principle, it applies to all companies with 50 or more employees and all authorities, meaning public institutions. These are also exempt from the employee number requirement. This means that starting from just one employee, they are required to implement it. Companies with between 50 and 249 employees can also choose a joint approach. This means that, especially in the case of corporate groups and subsidiaries, they could, for example, say, we have a shared office in the parent company, for instance. Now let's move on to the core of the implementation, the Central Reporting Office. By law, companies are truly required to set up a reporting office. This office is there to receive reports of misconduct within the company, to handle them confidentially, and of course to process them as well. Processing includes thoroughly investigating the matter. That means, does this report actually reflect a real situation? Is there perhaps more to investigate in this direction that hasn't yet been included in the report, and also to provide feedback? That is, to truly inform the whistleblower about what has resulted from their report and what follow-up actions, if any, have been derived from it. So what is crucial is not just the reporting channel itself, but also the underlying process for handling the reports that come in. What requirements actually apply to this reporting channel? First, it must treat these reports confidentially. This really means that only the smallest possible group of people should have access to these reports, or if names are mentioned, for example, that there are further gradations, so that before the report is processed further within the company, the information is anonymized, or it is checked whether the name actually needs to be passed on, or whether there are ways to restrict the information. There is a prohibition on retaliation measures. This means that the employee who submits this report, who provides this tip, must not experience any negative consequences. In other words, they must not be dismissed, receive a warning, or be disadvantaged in any other way because of their report. The legislator even goes a step further and says that if the employee does experience any disadvantage or feels disadvantaged, then the employer must in turn prove that it is not due to a disadvantage as a result of this tip-off. And there are clear deadlines that must be observed. This means that within 7 days, the reporting office must send a confirmation to the whistleblower that the report has been received, and within 3 months, there must be feedback on what has resulted from the processing of the report. So, what exactly can be reported? These include, for example, criminal offenses, administrative offenses, and violations of any EU regulations. General dissatisfaction of employees with another person, a colleague, or a member of management cannot be reported. That sort of thing is not included. So, what are typical mistakes when implementing such a reporting office? For one, you could say that the reporting office exists only on paper. This means that perhaps not all employees are even aware of the reporting office, and as a result, no reports are submitted. Or people simply don't know how to reach this reporting office. Phone, reporting form, something like that. It could also be that managers are not included in the process. That means they do not clearly support the existence of this reporting office. They do not encourage employees to actually use this reporting office. And that, in turn, can also lead to the fear of retaliation still remaining. And of course, it must also be ensured that the reporting office processes incoming reports promptly and provides feedback so that the whistleblower can actually see that something is being done with the report they submitted. That has an effect. So overall, it is not enough to simply set up this reporting office. It is also about explaining the transparent processes, training employees and saying, here, this system exists, and promoting this culture of open communication through company leadership. So why is it worthwhile to genuinely implement a whistleblower system? It helps to identify misconduct or potential risks at an early stage and to take timely countermeasures before they become a real problem. They strengthen trust both internally and externally and reinforce the compliance culture within the company. A functioning whistleblower system is therefore not a burden, but a preventive measure. In conclusion, it can be said that this Whistleblower Protection Act, which is behind all of this, does not demand perfection, but simply a functioning, transparent process in which all employees are truly involved and convinced. For more videos like this, feel free to subscribe to the channel and leave a like.